Welcome, everyone, to this recording of a couple of virtual workshops that we held titled Stopping Mega Mergers, How You Can Organize Against Monopoly Power. My name is Justin Stofran. I'm the Anti-Monopoly Director at the Minnesota Farmers Union and lead our work on antitrust and competition issues. If you're watching this and are unfamiliar with the Minnesota Farmers Union, we're a grassroots organization that's represented family farmers, ranchers, and rural communities across Minnesota since 1918. MFU members have long prioritized taking action to rein in corporate control and protect fair, open, and competitive markets. I want to thank you for taking the time to watch this workshop today and want to go over what we're going to be talking about. We're going to be talking about mergers, specifically the new merger guidelines that have been released by the Federal Trade Commission and the Department of Justice. We're going to explore what these guidelines are, why they matter, and then most importantly, cover what role that you can play in this process and the importance of making your voice heard. So what are these merger guidelines exactly? Well, before I dig in a little bit, I just want to frame up that terms like merger guidelines or antitrust might sound wonky or technical, but what all of this is really about is protecting farmers, workers, small businesses, and communities from monopoly power. It's about recognizing that how we structure the economy should be part of our democratic process, which means we all deserve a chance to have a say. Now, on this slide, in this picture, you'll see on the left is Assistant Attorney General for Antitrust, Jonathan Kanter, and on the right is Federal Trade Commission Chair Lina Khan. Their agencies release these guidelines, which serve as a guidebook for those agencies as they investigate and evaluate mergers. In particular, the guidelines serve as their interpretation of the Clayton Act, which is the key federal law regulating mergers. But another important thing the guidelines do is communicate to businesses, the public, and the courts about what kinds of mergers are anti-competitive and a violation of the law. The courts are a particularly important constituency for these guidelines, as they've referenced the guidelines over the years when making decisions on key antitrust cases. Not all judges are going to be intimately familiar with the antitrust laws or their staffs, and they rely on the legal theories communicated in the guidelines when making decisions. That doesn't mean that they're bound by the guidelines, but they play a key role. While the guidelines don't have the force of law and they're not rulemaking from the agencies, they're a key part of determining what sort of merger enforcement we're going to have in the United States. Are we going to recognize that mergers are often harmful to the economy and contribute to growing monopoly power? Or are we going to allow corporate power to grow unfettered? The merger guidelines play a key role in answering that question. It's why these guidelines are so important. It's also why last month the FTC and the DOJ proposed changes to the existing guidelines, last revised in 2010, and they're asking for feedback from the public, from all of you. In order to properly understand where we're headed with these new guidelines, it's important to understand how we got here. The Clayton Act, which I mentioned earlier, was passed in 1914 and is meant as a preventative statute that will stop monopolies from forming in the first place. It focuses on prohibiting mergers and other conduct that reduces competition. In 1950, the act was strengthened by passage of the Sellers-Kefauver Anti-Merger Act. It's right there in the name. And a report in 1978 found that aggressive enforcement of the law by the FTC had protected competition, even deconcentrating industries such as dairy processing, for example. In the midst of this, the first merger guidelines were adopted in 1968 and seen as a way to specify to the public the standards being applied when challenging a merger. The guidelines emphasized market structure and preserving and promoting competition. In 1982, however, a golden age of antitrust enforcement abruptly came to an end. The guidelines were dramatically changed to emphasize consumer prices and economic efficiency, not the structure of markets or protecting robust competition. This means that without a single change to the law, monopoly power was given free rein. While the guidelines have been changed in the years since, they have continued to adhere to this very narrow consumer welfare frame that really is contrary to the intent of our antitrust laws. All of this has left us with a highly consolidated economy, and it's not limited to one industry. Our members at MFU are very familiar with a small handful of companies that dominate the markets for the inputs farmers need and rely upon, as well as control access to the markets they need to sell their products. But this is not just an issue in agriculture. It's not just a healthcare issue or a tech issue. Monopoly power is pervasive across our economy. Between 1997 and 2012, 75% of industries became more consolidated. Since 2005, the economy as a whole has become 50% more concentrated. And at the current rate of consolidation, if we do nothing, we would be left with precisely one company come 2070. Mergers have played a key role in driving this consolidation. For example, in 2021, the value of global mergers and acquisitions hit an all-time high. On this slide is one of my favorite images for demonstrating the scope of monopoly power. It might be hard to see, but each slice in this chart contains a wide range of different brands. Brands that you might often associate as individual companies. But as you can see, each of those groups of brands is owned by just one company, giving the illusion of choice to consumers. And of course, harm like this to consumers is just one of the harms from concentration. It doesn't cover lower wages, greater inequality, the loss of family farms and small businesses, etc. Now, this might all sound a little bleak, but the positive thing is that this is about to change. It's the Biden administration, as part of its commitment to reinvigorating antitrust enforcement, has proposed a new set of guidelines. It takes a much more skeptical view of mergers and their impact on the economy. These new guidelines adapt to changes in the economy since 2010, such as the rise of the big tech platforms, but crucially also revert back to the purpose of the Clayton Act, which is to prevent monopoly in the first place. These actually would be the first guidelines that cite prior antitrust cases and antitrust law. Guidelines are based off 13 core guidelines that the FTC and DOJ have laid out. Among these core guidelines are the view that vertical consolidation is a potential threat to competition, that one merger might be part of a series of acquisitions consolidating an industry. I think, for example, in our work at MFU about JBS in meatpacking, which less than 2 decades ago didn't own a single plant in the US and used a series of acquisitions within a short period of time to really help corner the market. Another part of these guidelines is that mergers in highly concentrated markets can substantially lessen competition. I think, for example, as you see on the slide of the Bayer-Monsanto merger, 2 very large companies with a lot of market share already prior to that merger, creating an even larger company. These new guidelines also include a new focus on what's called monopsony power in labor markets. Monopsony power is sort of buyer power, and companies purchase labor. And the lack of competition in labor markets can create harms for workers, such as lower wages. The new mergers would also find a merger that creates a company with 30% or higher market share is anti-competitive, which is a much lower threshold than before. Finally, these proposed guidelines create new considerations for companies that have dominance in a marketplace. Now, before I move on to the next part of this presentation, I want to take a second to address some of the questions that came up in our previous live workshops. One was that I've mentioned that these are not rules or new laws. So again, why are these guidelines impactful? And one way to think about it is that these guidelines are a legal document, right? They are putting forth legal theories on antitrust. The antitrust laws themselves don't spell out every scenario that could happen in the economy. And so having these guidelines going into cases where the FTC or the Department of Justice are challenging a merger, right? That's the next step when they challenge a merger, is it creates a court case over that. And so again, back to the point I made earlier about the guidelines being an important tool for judges, that's a big part of the reason why these are so impactful. It's also impactful because a lot of the staff at the FTC and the Department of Justice, they're career staff, they're civil servants, they're not appointed by the president or there because of the appointees like Chair Khan or Assistant Attorney General Cantor. And that staff is going to rely upon those guidelines when they're investigating mergers, making recommendations to those appointed political officials. Another question we got is the Biden administration's proposal a good one? Well, it is certainly a strong break from the sort of consumer welfare focus that has undermined our antitrust laws for the last several decades. And so in that regard, I think it's a really good proposal, a really positive one. I think you'll find anti-monopoly advocates that believe the guidelines don't go far enough, and some who think they do go far enough. But I think it is clear that this is for those who are looking for stronger enforcement, a more skeptical approach towards mergers. These guidelines are doing that. Another question we've received is, can you break up companies after they've merged? This isn't necessarily specific to the merger guidelines, but I think helps underscore why the guidelines are so important, is that, yes, antitrust law allows for companies to be broken apart after a merger has been completed. Those cases tend to be really long and complicated and challenging, which I think underscores why it's so important to have strong merger guidelines that prevent those giant companies from forming in the first place. Final question we received is how these guidelines will impact state laws. State attorneys general do have authority to enforce the Clayton Act, that key merger law. And so these guidelines are going to impact the case law around that act. And so in that way, they're going to impact the way that state attorneys general approach these cases. Now that you have all of this context for why the guidelines are so impactful, I want to talk about how you can play a role in this process. As I mentioned, the FTC and DOJ are asking for the public to submit comments on these guidelines. The public comment period is open until September 18th, so you still have some time to get your comments in. Why is it important that you comment? Well, first, because it's critical that antitrust enforcers hear from the experts on the ground. They will hear plenty from lawyers and economists and even organizations such as ours with big picture comments. But that doesn't help them necessarily understand the individualized experiences each of you have had with mergers. So share your merger story, whether it is one that directly touches on your experience in an industry or has just impacted your life in some way. For example, 2 years ago, when the FTC and DOJ first asked for public comments on the idea of making these revisions, I submitted a statement as an individual that told the story of a merger my mother had gone through in her working years and what that meant to her working conditions as well as our livelihoods as a family. The staff at the FTC and DOJ might be really smart, well-credentialed, but they're not experts in every industry. And to our MFU members that are watching this, out of the over 2,000 comments that have been submitted last I checked, and when this video's been posted, there were only a couple of comments, maybe 6 to 8 nationwide from farmers. The agencies need to hear from farmers across Minnesota. It's also important to share your story, whether you're making critiques of this proposal or just asking the agencies to do something about mergers. The more comments there are on these guidelines, the more it sends a message, not just to the FTC and the DOJ, but the Biden administration in general, that taking on monopoly power in the economy is a priority. Otherwise, folks can create a narrative that people don't really care about corporate power. It's also important because as Minnesota Attorney General Keith Ellison recently told members of Minnesota Farmers Union their cases are made up of stories. The stories you share with antitrust enforcers are really, really important. Now, onto how you submit public comments. Doing so can be a little clunky, but we have created this link here that you can see, bit.ly/MFU merger. And what that will do is it will take you to this portal right here on the regulations.gov website, where you can submit your comment. You can attach files, include some contact information, and you can submit a comment as an individual. You can also submit a comment anonymously, which I know can be really important when talking about giant, powerful companies and their impact on an industry or on businesses that have to work with them. You can also, by clicking on the link here at the top, get more information on the guidelines. You can download the guidelines themselves if you want to read through them. You can browse through other posted comments. So again, all of that is possible by using that MFU merger link and navigating from there. Now that you know how to submit comments, I want to focus a little bit on or talk a little bit about what makes for a good comment. Although Chair Khan and Assistant AG Cantor are not legislators, I would think about these comments in the same way you might think about contacting your legislator. Be respectful and share specific parts of your story, and certainly do not feel the need to be wonky or technical. Actually, the agencies have told us they don't want wonky or technical comments. They're going to receive plenty of that kind of feedback. They want real stories from people on the ground. Because antitrust enforcers, again, to that quote from Attorney General Ellison about cases being made up of stories, antitrust enforcers cannot act just on data or technical theories. They need to know of actual harm that's taking place in the marketplace. And in this case, they need to know about the harms actual mergers have caused. Now, to demonstrate some good examples just of general comments, I want to start by showing some comments that were submitted to the FTC when they proposed to ban non-compete agreements. If you're not familiar, these are restrictive employment contracts that prevent workers from switching jobs. The first comment comes from Jane Jones, and she talks about a fair competition agreement she and her colleagues have been required to sign if they want to continue to receive their annual bonus. What's particularly powerful about this comment is that Jane shares a copy of the agreement in that attachment section. And this provides some really specific information for the agencies to utilize. The next comment comes from Megan, who's a PA in Duluth, and she talks about how non-compete agreements combined with consolidation in healthcare have allowed healthcare systems to drive down wages for healthcare workers. Again, this is a great specific example and provides some local details for enforcers to utilize. Now I want to show a couple of comments that have been submitted to the merger guidelines specifically. The first comes from Elizabeth Slattery, who's a retired physician in Minnesota. She's also an incredible advocate against healthcare consolidation. She tells the story of how healthcare monopolies forced her out of her independent practice and how they threaten independent physicians. Again, just to underscore, she doesn't say anything about the Clayton Act or the Anti-Merger Act or the Sherman Act or any of the acts. She doesn't say anything about consumer welfare standards. She's just someone telling her story about how mergers have impacted their economic livelihood and the future livelihood of folks in her profession. Another example is this one from Stan Moore, who shares his story about what consolidation in agriculture has meant for his life as a farmer. The story about him having to stop raising hogs after 28 years because of low prices is particularly powerful. Final comment I wanted to highlight, that's a little bit longer than some of the others, is this one from Nancy Dudley in Phoenix, Arizona, who talks about mergers amongst blood banks of all things. There are, again, I said monopoly is pervasive. Here's sort of a clear example of that. But she talks about how the mergers have been used to harm workers primarily, and is just another good specific local example. Also highlights an industry that doesn't often come up in our discussions about corporate power and monopoly power. So I want to thank you for taking the time to watch this recording. My contact information is here. If you have any questions after you've watched this that I didn't address or get to, please feel free to reach out by email or by phone. Once again, you have until September 18th to submit those comments, and I hope you will. And of course, if you're willing to share your story with the FTC and the DOJ, I would urge you to consider sharing it in a letter to the editor or to your legislator, your state legislators, or your members of Congress, etc. Policymakers need to understand that taking action to curb corporate power, whether it is these guidelines or a whole range of other reforms that we need to create fairer and open and more competitive markets. Legislators and policymakers need to know that that is a priority for their constituents. I'm biased, but I think people generally want policymakers, they want the government to take on corporate giants, but the subject doesn't often come up in campaigns or other venues. This is an opportunity with these comments or turning those comments into a letter to the editor, etc., for you to help ensure that this conversation is a prominent one. So again, if you have any questions, please feel free to reach out. Thank you for taking the time to watch this video and participate in this workshop. Thank you.